Texas Penal Code disorderly conduct, or what was known under common law as breach of peace offenses, can be thought of as irritating behavior society has decided it won't tolerate and raised to a criminal level. Though seemingly minor, these crimes are still significant because they regulate activity by individuals in public places. First, the Penal Code states a person who uses abusive, indecent, profane, or vulgar language which incites a breach of peace has committed disorderly conduct, and it's a C misdemeanor. A person who makes an offensive gesture in a public place which incites breach of peace has also committed disorderly conduct. It's also a C misdemeanor. Next, disorderly conduct is committed when a person creates by chemical means a noxious or unreasonable odor in a public place. Setting off a stink bomb or something similar is a C misdemeanor. A person who makes unreasonable noises in a public place or near private residences commits disorderly conduct as well. The Penal Code states a noise is presumed to be unreasonable if it exceeds 85 decibels after the person making the noise receives notice from a magistrate or peace officer that the noise is a public nuisance and told to stop. Should you play your stereo too loud and fail to turn it down after being told to by a police officer, you'll be charged with a C misdemeanor. It's important to note another Penal Code statute, section 42.04, states if conduct that would otherwise be a crime under this unreasonable noise section of disorderly conduct consisted of speech or other communication in a protest situation in a nonviolent manner for social, political, economic, or religious reasons, and the actor or actors had not yet intentionally harmed the interest of others, the actor or actors must essentially be ordered to reduce the noise level below 85 decibels prior to arrest. So in other words, if you are legitimately and non-violently protesting a social or political issue and singing, yelling, or doing something like making sounds which are unreasonable according to this section of disorderly conduct and haven't yet caused any harm, a police officer has to tell you to stop, and you have to refuse to stop by words or actions before you can be arrested for this offense. Next, a person or persons who fights with another in a public place commits disorderly conduct. Note, there are exceptions for what are essentially schoolyard fights between juveniles during school hours. Should two grown adults fight with each other in public, they'll both be charged with a C misdemeanor. A person who abuses or threatens a person in a public place in an obviously offensive manner commits disorderly conduct. The Penal Code states, however, it is a defense to prosecution the actor had significant provocation for his abusive or threatening conduct. Like the offenses we've previously viewed, this one's a C misdemeanor as well. A person who discharges a firearm on or across a public road commits disorderly conduct. This is a C misdemeanor, but keep in mind, this offense is simply referring to the act of discharging the firearm on or across the public road. If you're a handgun license holder, a felon, you cause alarm or panic, or your bullet hits a person, vehicle, or house, you could easily qualify for many different felony charges, such as aggravated assault or deadly conduct, to name a few. The Penal Code does provide a defense to prosecution for discharging of a firearm in a public place or across a public road if there was reasonable fear of bodily injury due to a dangerous wild animal as defined by the Health and Safety Code. Next, a person who exposes his or her anus or genitals in a public place and is reckless about offending or alarming another person has committed disorderly conduct. This doesn't refer to indecent exposure. Remember, indecent exposure involves sexual gratification or desire. This portion of disorderly conduct can be thought of more as public urination, and it's a C misdemeanor. Next, a person who, for a lewd purpose, enters onto property of another and looks through a window or opening, or, while at a hotel, looks into a room through a window or opening, or finally, while at a public place, looks into a restroom or shower stall or dressing room, also commits disorderly conduct. This offense is similar to the Penal Code offense of voyeurism, which was passed by the 84th legislature. Just like voyeurism, these types of disorderly conduct acts are C misdemeanors. Not all disorderly conduct charges are C misdemeanors, however. A person who discharges a firearm in a public place or displays a firearm in a manner calculated to cause alarm commits disorderly conduct, but it will be punished as a B misdemeanor. A common example is a road rage incident where one motorist displays but does not point a handgun at another motorist. He or she displays a firearm in a manner calculated to cause alarm and has committed a B misdemeanor disorderly conduct. There's a lot in this disorderly conduct statute, so let's briefly review. C misdemeanor disorderly conduct, while in a public place, includes abusive, indecent, profane, or vulgar language which incites breach of peace, an offensive gesture in public which incites breach of peace, unreasonable noises in a public place or near private residences, generally over 85 decibels, fighting with another in a public place, abusing or threatening a person in a public place in an obviously offensive manner, discharging a firearm on or across a public road, exposing your anus or genitals in a public place and being reckless about offending or alarming another, looking through a window or opening in a public place in a hotel or restroom or shower stall or dressing room for a lewd purpose, and finally, the B misdemeanor offense of discharging or displaying a firearm in a manner calculated to cause alarm. The First Amendment to the U.S. Constitution grants citizens the right to peaceably assemble. Peaceably is a critical word. The Texas Penal Code offense of riot covers situations when an assembly is no longer peaceful and endangers the common good. First, the Penal Code states the criminal offense of riot requires a congregation of 7 or more persons. You can't have the offense of riot with 6 or less. Next, those 7 or more persons must be doing at least one of the following. They must be either creating an immediate danger to property or injury, substantially obstructing a law enforcement or governmental function, or by force, threat of force, or physical action depriving a person of a legal right. It is a defense to prosecution. The assembly was lawful when it began, and the actor withdrew when it became unlawful. So if you were part of a peaceful assembly and left as it turned violent, but you were arrested as you left, you may offer this as a defense. It is not a defense another riot participant was not arrested, prosecuted, or was acquitted or convicted of a different offense. So you cannot use the fact that you were arrested but hundreds of other people who participated in the riot weren't as a defense. In general, the offense of riot is a B misdemeanor. However, the Penal Code clarifies the offense level can be raised to the same level as any offense of a higher grade committed by anyone engaged in the riot if the offense was in the furtherance of the purpose of the assembly or an offense which should have been anticipated as a result of the assembly. So, for instance, if you set a car on fire during the riot and you are arrested, you can be charged with riot, but instead of a B misdemeanor, the offense level can be a felony of the second degree, the same as if you were charged with arson of a vehicle, which is also a felony of the second degree. The First Amendment to the U.S. Constitution grants citizens the right to peaceably assemble. When another citizen infringes upon this and disrupts that assembly, it's not only socially unacceptable, but we consider it criminal as well. We'll discuss the Texas Penal Code offense of disrupting meeting or procession in this screencast. The Texas Penal Code has 2 similar offenses. Hindering proceedings by disorderly conduct is found in Chapter 38, and it covers someone who disrupts a government meeting and refuses to stop. The Penal Code offense of disrupting meeting or procession is similar, but it covers non-government and legitimate gatherings or congregations, such as a church service. The Penal Code states a person commits disrupting meeting or procession when he or she prevents or disrupts a lawful meeting, procession, or gathering, and obstructs or interferes by physical action or verbal utterance. All offenses under this section are B misdemeanors. The wars in Iraq and Afghanistan have resulted in the deaths of more than 5,000 U.S. servicemen and women. Some groups use the media focus on the funerals back home to draw attention to their own issues. Disrespecting the dead is not typically socially acceptable in our society, particularly dead soldiers, sailors, airmen, and Marines. In Texas, this conflict undoubtedly contributed to the creation of the Penal Code offense of funeral service disruptions. Do you remember this group? This is the Westboro Baptist Church. They traveled the country picketing the funerals of many servicemen and women, delivering a message that almost all of the country regarded as outrageous and offensive. Free speech is sacred to us, though, So the Penal Code offense of funeral service disruptions is crafted very carefully in order to maintain its constitutionality. According to the Penal Code, a person or persons who, during the period beginning 3 hours before a funeral service begins and 3 hours after the service concludes, pickets within 1,000 feet of the facility, such as a church or cemetery being used, commits funeral service disruptions. All offenses under this section are B misdemeanors. Penal Code Statute 4204 further limits this offense, presumably to help maintain its constitutionality. It states if conduct that would otherwise be a crime under the offense of funeral service disruptions consisted of speech or other communication in a protest situation in a nonviolent manner for social, political, economic, or religious reasons, and the actor or actors had not yet intentionally harmed the interests of others, the actor or actors must be ordered to disperse prior to arrest. So if you are legitimately and nonviolently protesting closer than 1,000 feet from the church or place of the service, or are doing so within the 3-hour window before or after the service and haven't yet caused any harm, the police officer or someone else in charge has to tell you to move or stop, and you have to refuse by words or actions to move or stop before you can be arrested for this offense. Speech is one of the most important constitutional freedoms we enjoy. As the old saying goes, though, free speech doesn't mean you have the right to yell fire in a crowded theater when no fire exists. At this point, your speech is no longer protected and falls under the Texas Penal Code statute of false alarm or report. The Penal Code states a person commits false alarm or report when they knowingly initiate, communicate, or circulate a report of present, past, or future bombing, fire, crime, or other emergency that is false that would ordinarily cause action by an emergency organization, place a person in fear of imminent serious bodily injury, or prevent or interrupt the occupation of a building, room, place of assembly, aircraft, or automobile. If committed in a manner which affects an elementary, middle, or high school, or a college or university campus, this offense is a state jail felony. If it affects public communications, transportation, water, gas, power, or utilities, it is also a state jail felony. All other false alarm or report offenses are A misdemeanors. Police, fire, and medical dispatchers are the unsung heroes of public safety. They deal with very stressful situations and frequently must try to communicate with persons who are hysterical, furious, intoxicated, or in crisis. We also understand that our 911 resources are sometimes limited, especially during a large-scale crisis. The Texas Penal Code contains the offense of silent or abusive calls to 911 service to ensure phone lines stay open so those who need help can get it. The Penal Code states a person commits this offense when they call 911 or a public safety answering point, sometimes abbreviated PSAP, when there is not an emergency and intentionally or knowingly remain silent or make abusive or harassing statements or permit someone else to do the same. All offenses under this section are B misdemeanors.
It's generally much easier for a person to threaten or make an obscene remark to another person over the telephone, by email, or by text message than it is in person. The Texas Penal Code offense of harassment is meant to cover threats and obscene suggestions sent and received electronically. The Penal Code states a person commits harassment when he or she, with intent to harass, annoy, alarm, abuse, torment, or embarrass, initiates communication and makes a comment, request, suggestion, or proposal that is obscene, threatens to inflict bodily injury on another or a member of that person's household, conveys a false report with intent to alarm of a death or serious bodily injury, causes the telephone of another to ring repeatedly, makes a telephone call and intentionally fails to hang up, or permits a person to use a telephone under their control to do any of those, sends repeated electronic messages in order to harass, annoy, alarm, or abuse, or finally, publishes on an internet website, including a social media platform, repeated electronic communications in a manner reasonably likely to cause emotional distress, abuse, or torment to another person, unless the communications are made in connection with a matter of public concern. A matter of public concern is a statement or activity regarding a public official, public figure, or other person who has drawn substantial public attention due to that person's official acts, fame, notoriety, or celebrity, and regarding a matter of political, social, or other interest to the community or a subject of concern to the public. The next part of the harassment statute is referred to as David's Law, which was passed in 2017 in memory of a teen who was cyberbullied and ultimately committed suicide. That law makes repeated communications which are likely to harass, annoy, alarm, and abuse that are made against a child younger than 18 with intent the child commit suicide or engage in conduct causing serious bodily injury an A misdemeanor. David's Law makes harassment committed by a person who has previously violated a civil temporary restraining order an A misdemeanor as well. A defendant with a previous conviction for harassment will be punished as an A misdemeanor. All other harassment offenses are B misdemeanors.
Stalkers cause their victims severe stress and anxiety, and stalking can almost be thought of as a type of mental assault. Stalking as an act has been around for a long time, but criminal laws against it are relatively new. The Texas Penal Code offense of stalking was enacted in 1997. The Penal Code states a person commits stalking if, on more than one occasion and in the same scheme, engages in conduct directed specifically at another that constitutes the Penal Code offense of harassment, or the actor knows or reasonably should know the other person will regard the conduct as threatening bodily injury or death for the person, member of their household, or with someone they have a dating relationship, or an offense against the property of another person, and it would cause a reasonable person to fear bodily injury or death for the person, member of their household, or with someone they have a dating relationship, or an offense against the property of another person, or finally, would cause another person to feel harassed, annoyed, alarmed, abused, tormented, embarrassed, or offended. A person who commits stalking and has a previous conviction under the laws of Texas or another state has committed a felony of the second degree. All other stalking offenses are felonies of the third degree. Finally, the Penal Code states the type of conduct described in the statute need not be exactly the same in order to qualify as on more than one occasion.